Good morning, everybody. Day 2 from gloomy New York City. Actually, we're all over the world, but I'm reporting from Brooklyn, New York, and really excited to welcome you back for day 2 of NYU Law Review and Bernstein Institute for Human Rights Symposium on Critical Legal Empowerment. For those of us that are coming back for round 2, I hope you found it as heart and mind expanding as we all did. I think there was just so many nuggets of wisdom that was shared yesterday from folks on the panel and from folks all over the world. So thank you for sharing your time and your space with us. Before we get started, just a housekeeping reminder that we are offering CLE for each of the sessions. And the CLE credits are appropriate for both newly admitted and experienced attorneys. To make sure your credits are counted, please write down the code that our moderators will be providing near the end of the session, and we'll also put that in chat and include that in your affirmation document, which you can get on our website. There's a link that says CLE, and then make sure you send that over to us and your credits will be counted. Okay, so now on to our first panel of the day. It's titled Community-Driven Litigation, Transferring Legal Power to Community, and it's moderated by the fabulous Gabrielle, Apollon, who supervises the Global Justice Clinics here at NYU projects on Haiti justice and international accountability and torture, rendition and detention. And she previously served as the managing attorney at The Door, a center for alternatives where she represented young people in immigration and family law matters. And there's much more on her bio that you can find on our website. And just one more thing before I shift it over, we will have live captioning feature available. It is available, so please do turn that on if you prefer. So Gabrielle, over to you. Thank you so much.
Thank you, Sukti, and hello, everyone. Thanks so much for joining us today. As Sukti mentioned, yesterday we had various panels and we delved into what critical legal empowerment actually means and what it looks like. We heard from leaders in this field about the power of accompaniment, as well as the effectiveness of community paralegals in many different contexts. And today we'll be exploring another strategy in this fight to make the legal system more accountable and justice more accessible to communities. And that's the strategy of community-driven litigation. And to help us do that, we're delighted to have these panelists who are practitioners and leaders in this space across the United States, who are really doing the work. We have both organizers and attorneys who've been grappling with this question of what it looks like to redistribute legal power to communities from their various vantage points in real time and on a daily basis. And before I get into introductions, I want to just give a sense of the panel's format today. So first, we'll have opening remarks from each of our panelists. I'll introduce them in turn, and then we'll open it up to conversation or Q&A, where I'll pose a few questions that'll hopefully enable us to kind of delve deeper into the panelists' work and the insights that they've developed regarding community-driven litigation through their experiences. So as we go, please feel free to drop questions into the Q&A box as they come up, and we'll aim to address or incorporate them as hopefully time permits. And as Sukti said, the panelists each have significant bios that you can find in the conference program or on the conference website. So I won't be sharing all of them, but I will give you a little bit glimpse of some of their work before they share their opening remarks. So, and thank you for those of you who are sending greetings via the chat. Please feel free to continue to do so throughout the panel. So today we're going to be starting with Antonia Gutierrez, who's an undocumented queer immigrant working on anti-displacement campaigns in Chicago, Illinois. They are the strategic coordinator and co-founder of OCAD, Organized Communities Against Deportations, which is an undocumented-led organization that empowers undocumented immigrants to resist ICE deportation and detention. I know he'll share much more about the work that he does, so I'll let him take it from here.
Hi, everyone. Good morning. Again, my name is Antonio Gutierrez. My preferred pronouns are they, them, theirs. And I'm one of the co-founders of Organized Communities Against Deportations and an anti-displacement organizer here in Chicago, Illinois. I'm really happy to be here with all of you and discuss this amazing legal empowerment strategy, community-driven litigation, that for OCAD has been useful as an organizing tool and as a tool to amplify some of our individual campaigns. At OCAD, or Organized Communities Against Deportations, right, we fight in support of individuals around their deportation cases. Many of the times, individuals that have a criminal record, right? So many of the times they have already interviewed or discussed their cases with many attorneys, and the attorneys assure them, right, that there was nothing that they could do in regards to like legal strategy, that they would just have to accept that they will need to get deported. So many of the times people come to us already knowing that there's very limited options and resources for them in regards to their case, but that never really has stopped us as an organization to continue to advocate to stop the deportation, right, and to continue to fight against the criminalization of immigrants. When we do an individual case or public campaign, we also tend to do it in regarding wanting to push or advocate for transformation of the immigration system or the terrorization that ICE or agencies like ICE have in the immigrant community. We tend to do this, right, by amplifying these public campaigns and connecting them to violations of human rights, violations to internal memos that ICE is supposed to be implementing, or just by also by implementing, sorry, I got distracted by the chat, but also by implementing many of the things and continue to push on the administration, whether that is the presidential administration, other Congress people, or ICE in itself, right, to continue to advocate for better policies and better treatment of our communities, and not with the reformist lens, but always with the liberatory lens, wanting undocumented people to be leading that process, as we are an undocumented-led organization. Myself, I'm undocumented, and I've been in the US for about 21 years, and that's the type of leadership development that we want to have in the organization. Without that type of leadership development, then we could really lose track of what is important, what matters the most to our undocumented community, and in having members and leaders in the organization that still live with the lived experience of what it means to be an undocumented immigrant, what it means to have the anxiety of having ICE show up to your door and knock and want to detain you or separate you from your family. It's really important for us to be able to customize our campaigns and the work that we're doing in order to adapt to those needs and best serve our community. We also consider ourselves as OCAD, not a service organization, but an organizing platform for undocumented immigrants. When we first interact with the individuals during our intake process, we tend not to have an attorney present in the first interaction or meeting. We tend to rely on the meeting as a building relationship meeting. And so that's gonna be really important in regards to the way that we are developing these relationships, all the way to some of OCAD members being part of the organization now for about 7 years. And the organization started back in 2013. I'll leave it at that, but I'm really excited to discuss some of the litigations that we've been able to do with all of you, and also the way that we have seen community-driven litigation be used as a way to win anti-deportation campaigns. Thank you.
Thank you, Antonio. I now want to introduce Ramzi Kassem. He's a law professor at CUNY, the City University of New York, and the founding director of CLEAR, which stands for Creating Law Enforcement Accountability and Responsibility. And in support of clients, communities, and social movements, Ramzi has litigated many different types of cases, including civil rights, constitutional, immigration, national security, and the list goes on. And so I will let him take it from here.
Thank you so much, Gabrielle, and I'm very both honored and privileged to share space and to share this panel with everyone else here and with all the attendees as well. I wanted to maybe talk a little bit for starters, and I look forward to the questions and conversation later about community-driven approaches to litigation, movement lawyering approaches to litigation. The clinic that I work in at CUNY that Gabrielle just mentioned, CLEAR, is committed to a movement lawyering approach broadly. And so obviously in our mandate area. And so the area that CLEAR works in is to work with movements and with communities that are particularly targeted by the sprawling US security state and all of its manifold expressions and manifestations, whether that's immigration, criminalization, surveillance. And what that's meant for my students, my colleagues, and I is that we have been present in various movements, in various communities. Primarily, the constituencies that we've worked with and served have been Muslim identified, both Black and non-Black Muslim, as well as non-Muslim Black communities, because those are the constituencies that have been primarily targeted by the US security apparatus, but increasingly other constituencies as well, including journalists, including environmental rights activists, animal rights activists, but primarily Muslim and or Black communities. I'll give one example, among many of what that's translated to in practice. The conventional, I think, strategic or impact litigation approach is for a legal nonprofit organization to parachute into a community or movement because lawyers at that organization have decided that there's an issue that they think is important that needs to be litigated for the development of the law, quote unquote, and that's what sort of drives the litigation effort. It's a very top-down approach, and it's the opposite. And there is a place for that. I don't mean that as a complete critique, but the approach that we take is more of the flip of that, where it's from the ground up. And one of the examples I would give is the litigation that was ultimately brought to challenge the NYPD's previously secret Muslim surveillance program here in New York City, but actually like all over the United States and worldwide, the NYPD was active in this particular enterprise. And the way it started for us at CLEAR is that we had been working with communities and movements that had been pushing back against police surveillance and criminalization of entire communities. And in 2011, there were documents that were leaked to the Associated Press that confirmed, they weren't really revelations, they were more confirmations of what these communities suspected and knew for a very long time from their lived experience, which was that they were being watched very closely, that the police was keeping files on Muslim identified businesses, that they were going into delis and creating secret police records about whether there was a Muslim in the back working behind a counter. I'm not making any of this up. They documented every aspect, or attempted to document every aspect of Muslim public and private life in New York City and beyond, on the assumption that the entire community was a threat, and that increased religiosity would place people on a conveyor belt towards acts of indiscriminate political violence. And that's what was driving the entire enterprise and leading the police to infiltrate mosques, bookshops, cafes, even people's homes, noting if they had a copy of the Quran on display, for example. So all of these records were made public, and the communities and movements that we had been working within convened and were they were planning what the response was going to be, and it was a manifold, it was a sort of a multiple pronged response that was developed by this table of organizers. It included pushing, it included protests, it included lobbying city council and the mayor's office and the police department. It included going to the Department of Justice, working with the media. It also included answering the claims by the city that this surveillance program was both harmless and lawful. And so on those fronts, they tasked CLEAR as one of the legal organizations in the room to come up with responses to that. And so to the claim that it was harmless, we worked with organizers and activists and community members to put out a report titled Mapping Muslims that gave the lie to this claim that surveillance was harmless. And that report was used by organizers, used by city council members in oversight committee hearings where they literally pressed the police commissioner to answer to the report. So that was one prong of the response. And the other one was, the communities felt that there needed to be pushback legally, since the mayor and the police commissioner at the time were claiming that surveillance was also lawful. And so what we did was, working in collaboration with activists, it was a multi-year effort to develop a litigation that was accountable to, the movement-defined objectives, the community-defined objectives of, and the broader strategy with respect to surveillance and over-policing. We brought in colleagues from the American Civil Liberties Union, the New York Civil Liberties Union, and a private law firm. And to their credit, they were individually and as organizations flexible enough to depart from maybe the more conventional approach to cases like this, and to and to follow a community-driven and movement lawyering model in terms of developing this litigation. That kind of process is much slower, and I'll conclude in a couple of minutes. That kind of process is much slower than the top-down approach, but it is far more in line with community objectives, movement objectives, and more importantly, far more accountable to community leaders and movement organizers. The ultimate outcome was successful in that it resulted in an unprecedented set of reforms reining in a law enforcement agency, a surveillance agency, an intelligence agency for the first time since 9/11. So that was an unprecedented success. It took many years to get there. One of the challenges among many that I'll highlight is that because of the rules that constrain lawyers in active litigation, once we reached the stage in the litigation where the city wanted to sit down and negotiate, and what prompted them to do that were two things. One, we won in court an order compelling the police to produce text messages between police handlers and their informants that were tasked with infiltrating communities and mosques. Those were the crown jewels. The police didn't want to give up those exchanges, those communications where the police is telling its informants where to go and what to look for and what to do. And then the other thing was, Bill de Blasio was elected, so there was new political winds were blowing. But when they sat down to negotiate, the rules of evidence kick in. Negotiations are supposed to be confidential, and that created a barrier between us and the organizers and community leaders who were not plaintiffs, not officially plaintiffs in the complaint, but in the litigation, but with whom we had been collaborating for many years. And so that's a challenge with community-driven litigation, movement lawyering litigation approaches, because once those rules kick in, anyone who is not officially a plaintiff is no longer in that circle, no longer in that conversation. And we could talk maybe a bit more later. I'll stop here about how do you navigate that particular challenge.
Thanks so much, Ramzi. And I think we will get to that. We will discuss that later. So I'm glad you brought it up now. And lastly, we have two additional panelists who we're excited because they actually work together on a daily basis outside of this panel. And so I will provide both of their introductions, and then they will be presenting kind of jointly about their work. So Alana Greer is the director and co-founder of the Community Justice Project in Miami, Florida. She is also an Echoing Green BMA Fellow and an advisory board member for the Dream Defenders, Law for Black Lives, and the New Florida Majority. Christina Francois, who is our final panelist, is the secretary of the Black Collective, which is a movement committed to promoting a shared agenda to elevate political consciousness and amplify the economic power of Black communities. She's also the other Haitian immigrant in this panel, which I have to shout out. And if that's not enough, her day job is the executive director of the Office of New Americans for Miami-Dade County. So I will let you all take it from here.
Thank you so much for having us, and we've been really looking forward to this conversation. I can share a little bit more about the Black Collective and how we're currently, what led us into this litigation right now against HB1, our anti-protest law that the state passed last year. So just for a little bit of context, Miami is, a historically Black city in the Deep South, where more than half of their Black population is actually immigrant. And so really the Black Collective was born out of the need to break down silos and divisions and really do intra-diasporic organizing and deep political education in order for us to build political power for our Black community in the state, and in a state where we really are the testing ground for some really horrible laws that end up popping up in other states across the country. So we can fast forward to summer 2020, where, the summer of racial reckoning was actually the summer where we launched our first political education, I would say like boot camp, Freedom Summer. And as protests are taking place all over the country, our governor, Ron DeSantis, decides to make very inflammatory and alarming comments, which which later in turn manifests into a proposed law regulating protests in our state, and really restricting our First Amendment right, which then gets fast-tracked in the following legislative session in Tallahassee, and it is literally called HB1 because it is the number one it was the number one legislative priority for both the Senate and the House, as well as the governor. And so this law, which I'll like pass to Alana to kind of break down a little bit more of why this was so alarming, really antagonized our communities, and really was laserly focused on the effective organizing. How do we criminalize the really effective organizing strategies that had taken place over the past summer? And so we were fortunate enough to have an organization like CJP in our community, where we had deep personal relationships and past work experience together. So as this bill was being introduced and fast-tracked, I can even really pinpoint who reached out to who first to say, like, are we doing something to stop this? But really, we first tried to we had made sure that we had a full legal analysis of the bill itself, so that we could actually effectively engage our legislators in order to stop the bill. Once we moved on to that phase, we tried to adopt an amendment strategy to see if we could remove the most harmful portions of the bill. And then, given that this bill was actually, just rammed through, we immediately started strategizing around a legislative litigation strategy to be able to get it overturned. So that's a quick timeline, but I'm sure we'll share more.
Thanks, Christina. As Christina said, it's such a joy to be on this panel with so many amazing folks, and especially with our partner and friend, Christina, and the Black Collective. So Community Justice Project is a movement lawyering organization based in Miami, but we work across Florida, supporting racial justice organizers in campaigns. And our goal is really to bring legal research and arts tools to the movement, and really support from behind in any way we can. And litigation, we really see all of those things as tools primarily, and try really hard to, especially for myself and the lawyers in the team, not to see litigation as our only tool or as our primary tool, but one thing we have at our disposal. And I think this case, when we're in a defensive posture, like we have been with our current governor and legislature for far too long, unfortunately, we've had to tap that tool more often than not. But because I think we have such strong organizing partners, it's really helped us do that try to stay as close to our values as movement lawyers through what can be a really challenging, complex court process that is not built to give voice to community. It's not built to really create space to to reach the targets, and I think reach the outcomes that community leaders and that organizers really want to see. And so there's work to be done to make that process fit the goal. And we'll get more into this, I think, during the panels. But I think what was really great about having such strong organizing partners on this piece of litigation in particular was really deeply engaging on the strategy of what the litigation looked like, not just the narrative, not just the press conference or an action that we might do, or the media around it, but how are we shaping this actual piece of litigation in a way that's really going to be about what the vision of this work looks like for folks that are most directly impacted by it. For us in Florida, that meant a really clear directive early on from Black Collective and other groups that the plaintiffs in this group needed to be Black-led organizing groups, because that was clearly who was being targeted by this law. And that needed to be the centerpiece of the litigation. And that wasn't the only legal theory that could have been brought or that was floated, but it was really important that was centered, and that was the clear drive. And that became, I think, really, not only was that vital for the organizing, but I think that made us stronger in court. It gave us a stronger argument when we really listened and responded to that. And we also, even just like some of the tactical decisions around litigation, like whether or not to pursue a preliminary injunction, was something that was really, that came from the organizers and from the reality of what folks were experiencing on the ground. The reality of like, I don't know if I can bring my folks out to a protest tomorrow, and we need to have access to that tactic because of the real fear of what was going to happen with newly empowered police departments that had already been so violent to Black communities, to immigrant communities. And so really taking that into consideration and building that in, I think is such a huge asset to lawyers doing this work, and really makes our work stronger, even though I think, like Ramzi said, it doesn't make it a faster process or a more efficient process, right? Like there is a lot of work to go in to really hold ourselves to the accountability to our clients, and to making sure that that this piece of litigation, that any tactic we bring is really going to be useful to the movement primarily, right? And we also know that there's no complete win we're getting from the courtrooms. This isn't our only site of battle, right? It is a piece of it. And we need to understand that, I think, in order to effectively use it. And we've tried, I think with this particular piece of litigation, we, like Christina said, we were working, using legal tools with organizers in various spaces in the legislative process, making sure folks had access not only to, what are the potential things we could fight for on this, but like really working with folks on translating the legalese that they were putting out to, okay, what does this mean for this group of people? What does it mean for youth protesters? What does it mean for someone who's undocumented? What does it mean for organizers who are promoting an event? Like how do folks really understand this so they can shape opinion around it, so they can explain it to their base, was a really important piece. And we also tapped into non-US systems. We worked on communiques to the UN and to other bodies to kind of spread the word, because we knew, unfortunately, from our experience here in the South and in Florida, that the courts and our political and legal systems are not always sites of validation or of relief for us. And so really trying to tap as many folks possible. And the last thing I'll say just about Community Justice Project in our work, I think that has been an asset as like a locally rooted organization, is we get to, I think one of the reasons we had deep relationships with folks like Christina is because our work, we're not an issue-based organization. We work broadly on racial justice, but really try to be fluid with organizing as it comes up. So that means we get to do litigation and use other tactics on a variety of fronts. So that could look like working with 20 tenants who are organizing a building, or it could look like working with incarcerated folks who are trying to get out during the COVID crisis, or just get basic necessities like soap and access to cleaning supplies. And so I think that's been a really, as a practitioner, someone who's still learning and honing her craft, I think being able to take lessons from those different experiences has been really, really beneficial in trying to build towards doing this work in a rooted way, and trying to not mess up on it daily, even though we do. So I'll send it back to y'all. I'm excited to keep this conversation going.
Thank you all so much. There's so much that you all brought up that I think we want to dig deeper into in these questions. I do want to go back to one thing, Antonio, you mentioned, and I'd love to hear kind of from all of you on this question, but Antonio, you mentioned that in your first meetings, you don't bring an attorney when you're meeting with community members. And I think, we all know that, lawyers are often given a lot of deference in these spaces and seen as the experts. I'd love to hear more from you about how other ways or kind of delve deeper into how you address those power dynamics, and maybe other strategies that any of you kind of use to build trust and, like we've said, redistribute legal power in the community. But if that's okay, we'll start with you, Antonio.
Yeah, that's fine. Thank you, Gabrielle. Yeah, so in relationship to how we shift or transfer the power that exists within conversations, right, of kind of the attorney-client relationship that we all have, like, in some way, right, interacted with. Within that dynamic, we always, as you simply put it, right, we always see kind of the attorney as the expert, as the individuals that have all the answers to the many issues that we might be facing. And that wasn't something that is okay that we have not seen, right? Like, we actually saw it a lot in the beginning of our work. First, because many of the co-founders of OCAD, we come from the Immigrant Youth Justice League or AJO, which was one of the organizations here in Chicago that was undocumented youth-led, that was pushing for reforms like policies such as the DREAM Act. Eventually, it started doing direct action that was also pressuring the Obama administration. So eventually it gave us like the Deferred Action for Childhood Arrival, or DACA. And when many of us were actually able to get a work permit or to have security that we were kind of excluded from the deportation machine, that's when we started seeing that all of a sudden our community, our parents, the street vendors on the street were technically disappearing from our community. They were getting detained by ICE. And so that's when we made the switch to start focusing more on deportation cases and really had to learn what it meant to do anti-deportation work. Until that point, right, we had kind of supported individuals that come to us, especially dreamers or youth that was undocumented. But now we were working with individuals that were not youth, that they weren't college educated, right, as many of us were, or getting access to higher education was not a goal. And so when we had to kind of learn that process, we did have an amazing ally organization that supported us through that kind of learning curve that we all had to do, which was Beyond Legal Aid, back then formerly known as the Community Activism Law Alliance. And having somebody like Lam Ho, who is the executive director and founder of Beyond, really allowed us to understand that it was possible to have an understanding and an expectation that attorneys were going to listen to the organizing strategy, that they actually wanted to collaborate together and make sure that the community, especially that individual directly impacted by the case or that was leading their case, needed to be part of those legal strategy conversations. That it wasn't just about having a room full of attorneys telling us what the options were and for them to determine what made more sense based on the legal strategy. Because as I was mentioning in my opening remarks, many of the times the individuals that OCAD was working were cases that attorneys didn't want to take, right? Like we went to many nonprofit legal aid organizations, and many of the times, especially in the beginning, they weren't supporting our cases or the individuals that we wanted to kind of collaborate with because they didn't see any potential win through the legal system. It wasn't until much later, right, that we continued to push as OCAD and that we started winning kind of this overall like anti-deportation like campaigns that we were doing. And all of a sudden, right, like the individuals that we were working were not getting deported, regardless of what was kind of the criminal record behind it. We were able to mobilize the community, not only by decriminalizing kind of aspects of what the immigrant community has gone through, right? But to really humanize what it meant to face deportation, what it meant to like deal with the trauma of potentially being separated from your family, and kind of shifting the narrative that has been told in the media so that we could gain that narrative back ourselves and tell it from our perspective. And so that in itself was a moment of empowerment, as well as a learning curve that allowed us to see that if Beyond Legal Aid was willing to listen to us and collaborate with us the way that we needed to do in order to really win the cases that we were taking on, that other organizations were going to have to do the same, or that we were not going to be working with them, right? Because we don't need individuals to continue those type of like narratives or dynamics of power, even within our meetings. We're trying not only to address the terrorization of ICE, right? But within our work, we fight against the criminalization. We understand how racism and white supremacy are the basis and foundation of our immigration system. And all of those concepts and political ideology is important for us to discuss with our members as part of the leadership development in order for them to come equipped into those meetings with an understanding that they're going to be the ones deciding on their cases, that both the attorneys and the organizers of OCAD are there to provide options and resources in regards to what they hope to win, or what they hope to demand. But that at the end of the day, it really is gonna take their own capacity and energy and making sure that they're working with both the legal and organizing strategy for them to be able to win. So those are some of the things that I will mention, but of course there are many differences between kind of traditional litigation and community-driven litigation. And I think one of them is kind of what people have been discussing, right? Like making the space for community like individuals to be part of those like initial conversations of legal strategy is going to be very important. And the unification of organizing and the legal strategy is what really creates like transformation. We tend to think at OCAD that the legal strategy tends to be our shield, right? Like those are the protections, the rights that we already have, but you won't go into a battle with just a shield. You need a sword, and the sword is the organizing, is the one that is pushing the boundaries, is the one that is thinking creatively, is thinking outside the box, and that we all understand, right, that the law is not just. The law has been created many of the times by many of the systems of oppressions that we have, like that we're discussing today, and we need to be modifying, we need to be changing those laws in order to adapt and to also resemble the oppressions that people are living on the ground. But yeah, that's kind of what I would mention in regards to that.
Thank you so much. And as people have been mentioning in the chat, that I think that shield is really powerful and something to remember. Is there anyone else who'd like to add to that?
I think in our case, it was really important for the organizers to actually be leading the narrative inside and outside of the courtroom. And so when we were deciding, you know, what grounds we were going to base our litigation on, there was a very, very intentional conversation with all of the co-plaintiffs and all of the legal team to see what we as organizers and as community prioritized. And what was helpful was that we worked seamlessly with our outside narrative, right? So I know that Alana dropped in the chat, we created a landing page where we wanted to make sure that the community was very aware of why we were choosing to challenge the state, on what basis, and laid out that same argument to the community as well. And we paired that not just with you know, a traditional press conference or something like that, but we actually did canvassing. We did canvassing not only to educate folks on the law and the impacts on the law on Black communities across the state, but also we gave opportunities for folks to volunteer to canvass, to be able to kind of do train the trainers on the impact and know your rights presentations, hand in hand with folks, to say that actually there weren't attorneys at the front of the room that were the ones telling folks this is how it's going to impact your community and to know your rights, but it was actually organizers and community members that were educating and informing each other. And I think that we were lucky to have legal partners who understood that we were not just thinking about this particular case as winning a particular case, but really laying the groundwork for what this means for our communities in the state of Florida and outside of the state of Florida. And winning is not just about winning this particular case, but it's about setting precedent for, you know, the 13, I believe, other states that are challenging similar laws. And so it is really important to think about defining who is the impacted community and what success or winning looks like. And having that alignment really makes a difference in terms of building trust, because we know that we're all moving towards the same goal and we're all centering the right people.
And I just have to shout out Christina. I mean, because I think the work, especially when you're talking about like more complex litigation, federal court litigation, things like that, I think it's really easy, even for a dedicated lawyer, to get lost in the process that requires. And we have an amazing, really big team of co-counsel and pro bono counsel. And I think the organizers, in our case, Christina in particular, really took the time to create like a group, organizer-led, plaintiff-led group to do the work to create that narrative. I mean, we really had to create extra process and space that wasn't part of a traditional litigation plan, and build relationships between these groups to make sure that narrative was front and center, and to work through like the differences in the way lawyers might think and talk about things and the way organizers wanted and needed to talk about these things. And so that took a lot of energy and effort, I think, and the organizers were really there to make sure we were held accountable, so our whole legal team was held accountable. And I think that's why I think I'm so proud of some of the things that have gotten put out because of that effort. So shout out to Christina.
Yeah, very, very inspiring to hear from Christina, Alana, Antonio. I'm very grateful for everything you're sharing, and it resonates so much with with things that I've been thinking about and working on. The only things I would add, and I'll try not to repeat what was said, which I agree with like entirely, in response to Gabrielle's question is, I think for lawyers and legal organizations that are serious about supporting movements and supporting communities and working in movement and within communities, you have to think very intentionally about which spaces you integrate and how you move in those spaces and what direction you take in those spaces. And so by that, I mean, very concretely, I mean, we have these conversations with our students in the clinic. Where are the meetings taking place? Are they taking place at your offices, or are they taking place, where organizers typically meet or community leaders typically meet? And then once you are in those spaces, right, as a guest who is there, as a partner who's there to support, what is your default position? I often get the question from students, okay, well, what should we do? What should we say? What should we prepare? And our advice, to students, our recommendation is, to the student teams who are working on supporting, power shifting and movement building initiatives is, a large part of what we're going to be doing is listening. And that's not new. There's a long line of radical lawyers and movement lawyers who've said that, including, Jerry Lopez as early as, the 90s, about in his book Rebellious Lawyering, that's a very large part of what you're supposed to do, at least initially, if you're serious about this form of lawyering that is, accountable. And then in terms of, what happens next, a lot of people will ask, well, how does CLEAR decide what cases to take on? And my response to that is always to say, like, we're not burdened with that decision, because every single, major litigation that we have taken on has been one that was identified by the movement partners and community leaders and organizers that we work with as a priority, and as part of a much broader strategy that was not limited to formal litigation outcomes. And so in that sort of effort, it matters much less what the formal outcome is, because you could lose in court in a narrow technical legal sense, but still prevail on the broader movement objective that you're trying to secure. And just to echo one thing Antonio said that Christina and Alana picked up, it's sort of a truism at this point that, but still worth repeating, I think, especially to younger lawyers who are trying to acclimate and figure out their place in the work, that the law, at least in the historical experience of communities of color in the United States, and I would say even more broadly, has been far more often, a system of oppression than an instrument of liberation. Once you understand that, it doesn't mean that the law doesn't have a place. It doesn't mean that the legal system doesn't have its tactical and strategic uses, but it really sort of calibrates your expectations and helps you figure out your place as a lawyer in a movement and the place of that particular tool, in a broader strategy. So, we've never had to make the decision of like, oh, well, which case are we going to prioritize? Because it's not our place to make that decision. Of course, we're a part of the conversation, and when we inform the conversation, but these are decisions that need to be made by those who are most proximate to the pain. And that is very rarely lawyers, who tend to be, in a position of economic and social privilege, even if they have personal ties to deeply affected communities.
Yeah, that is also so important. Thank you. I have to intervene and mention the CLE credit. First, just quickly, speaking of lawyers, for participants seeking CLE credit for this session, the course verification code for community-driven litigation is at CAPS TLPTC. Again, that's TLPTC, and thank you to Sikti for putting it in the chat as well. But going back to something that both you, Ramzi, and Alana mentioned in your opening remarks, and I think someone in the chat also picked up on, it just sounds like community-driven litigation has very different challenges at various stages of the litigation, whether it's the settlement negotiations, like you mentioned, Ramzi, or deciding on the initial strategy. Like you mentioned, Alana, I think to everybody, what are overarching principles or practices that your organization seeks to implement that have proven useful to navigating that entire process? I think you all have been bringing those up as we go. And, in other words, and in the Q&A, I think the question's also, what are those key success factors to remaining true to a community-driven model? Feel free, whoever wants to start.
I think the two that pop out to me, I think one, especially with complex litigation, the timeline of it, right? So we're right now in litigation around some anti-immigrant laws and policies here in Miami-Dade that has stretched in a timeline where the campaigns and the priorities of the organizers have shifted during that time period too. And so I think so the usefulness of that for the organizers, the ways people engage with it changes over time. And obviously we're in the case, we're not going anywhere. And so I think really being understanding that flow, understanding that these don't work on the same timeline always, but being ready to go back to the table and bring that information back to the organizers and be in a relationship with that struggle is really important. And being okay with that, right? Not being in control of those things. And then I think I wrote this up earlier about some of the settlement questions and what happens. That really has struck me, particularly in some of our housing cases, where the organizers might be technically third parties to a litigation, right? They're not plaintiffs in the litigation. So I've had many times where the landlord or the mobile home park owner, whoever it is, refuses to let the organizers in the room for a mediation. And the rules of that mediation are confidentiality, are ways that are oppositional to what transparent participatory work really looks like. And that early on in my career caught me by surprise and put us in, I think, really tough situations. At this point, I think we really try to make sure the organizers understand all the limitations of a space so we can strategize around that up front and we can figure out how can we confront this? Do we want to use this as a forum, understanding those? How can we make sure that it's still useful to the bigger goal? And really think about some of the specifics of things that might be boilerplate in other cases. So things like a confidentiality term that every other lawyer just throws in there actually could have huge ramifications for how tenants could speak to the organizer that's supporting them. And so how we really think and challenge those kind of default measures that courts and systems kind of ask us to put forward.
Yeah, I will agree with all of that. And I think I want to go back to a point that was made already, but a really important principle for us at OCAD whenever we are going to be doing some kind of litigation for any of our cases or much more broader kind of policy campaign, it is not about winning the litigation. It is not about winning that in court. That has never been the goal when we have decided to take on a litigation project for us, as we understand, right, how the court system, the legal system is not there to provide us those wins. For us, it's really about setting up those precedents, as other panelists have been saying, and to allow our community demands to be heard, to be part of the narrative, to be paid attention. And many of the times we have seen how the media pays a lot of attention whenever we are filing a lawsuit against the city of Chicago, as we have done before, against ICE, right? Because that tends to provoke some kind of understanding that if community groups are doing this, that is outside the box, right? And that is news to be told. And yes, it gives the platform for a narrative to be part of the conversation. That is one of the principles that I think we relied on when we do community-driven litigation. I also want to give proper credit to the shield and sword metaphor that actually comes from a model of organizing of City Life Urbana, who does anti-eviction, anti-gentrification work in Boston, Massachusetts. I'm also one of the co-founders of the Autonomous Tenants Union here in Chicago, which does anti-eviction work. And so we have collaborated with City Life Urbana, and that SOAR and SHIELD has been a key component of the model of organizing that OCAD, ATU, and overall, like my understanding of community work and development relies on that type of collaboration between legal and organizing strategy in order to really create transformative policy and transformative wins for our community. I think when we are looking at litigation and we understand that we are receiving some kind of like pushback from attorneys in regards to what we are hoping that this lawsuit or litigation will accomplish, or that maybe our demands might be taken as too unrealistic, right? That in a way we are doing our work properly the way that we want to do it, because we want to push back. We want to continue to push those boundaries. If we feel comfortable with the conversations with the attorneys, right, then we're not being good organizers, we're not agitating them or the community members that we might be working with that are directly impacted. And if attorneys are comfortable within the conversations that we're having around strategy, well, they are also not really listening or practicing community-driven litigation or community lawyering in other terms. I think the accessibility of legal language and legal strategy needs to be given to our community. And that means going beyond just translating documents or filings from English to Spanish or any other language that your community speaks. But it really is intentionality about explaining the timeline for the legal strategy, making sure that individuals, not organizers, but the individuals themselves that might be individual plaintiffs understand why we're doing certain things, why we're doing court support, why it's like important for the judge to understand that this is not just a singular isolated lawsuit, right? But that is an understanding that there's a community demand, a community support for it, that only really comes when you are able to amplify the litigation beyond the courtroom and really bring it back to the community and to the public so that they're engaging with that timeline and they want to be asking and for you to be providing updates about the litigation in itself. And I think the last thing that I will mention is kind of these like settlement conversations. I think with settlements, right, we always relied, especially if the litigation is based on individual plaintiff community member that is part of OCAD, we always relied on what they need and what they want and how do they want to settle this litigation. They're going to have the final word into it, and the organizing agenda that OCAD could potentially have in regards to what we hope to accomplish with the litigation is not as important, is not the priority within those conversations. But we've been a plaintiff as an organization, then that plays a different type of like scenario for us, but really is about the pushing those boundaries and making sure that even if we do negotiate, right, with the city of Chicago or with entities like ICE, that it comes from a place and an understanding of liberation, that we can accomplish certain like wins and pushbacks, right? Or that we get to have them acknowledge what they are doing wrong. That in itself is already a win in the way that like we see that type of litigation.
Thank you so much. Yes, please go ahead, Ramzi.
Yeah, I mean, I think there's a couple of things I want to say. Like one about just sort of like more normative, like strategic objectives and being clear in conversations with like community and movement partners about that. And so like, you know, to go back to the example I mentioned, like the lawsuit that we ended up bringing to challenge NYPD surveillance, right? You know, there was clarity in the many hours like of conversations and meetings had with community organizers and leaders that, you know, that particular prong of the broader effort was not going to achieve the deeply transformative or even abolitionist objectives of those organizers, right? In the sense that, was it going to put an end to the NYPD's ability to conduct surveillance of political organizing and religious activism? No, it was going to potentially constrain it. It was going to reform it. You know, we had very explicit conversations about, well, you know, is that a useful reform as a stepping stone towards something more transformative where we would, you know, dismantle that apparatus, which we all agreed was, you know, a necessary objective. But there was clarity, that this strand of the broader effort, the litigation strand, was not going to be the pathway to that. And I think it's important to have that clarity for everyone involved, including the lawyers, and for the lawyers especially to know that it's a stepping stone, that it's part of a larger strategy, and that we don't dictate as lawyers the larger strategy. Individually, we could be organizers as well, and those are distinct roles. So within those parameters, I would say lawyers have to still think very creatively and find ways to resist the ways in which the law operates to individualize and atomize and to defeat really community organizing or movement building. So to make that very concrete, in connection with the example I mentioned, right? Like we had these settlement talks, this was complex federal litigation, the federal rules of evidence kicked in, and all of a sudden, we can only talk about what's being discussed at the settlement table with the plaintiffs in the case. We can't talk about it with the broader ecosystem of organizers and movement folks with whom we had been in conversation literally for years at that point. So what do we do to resist that, right? Like what can we do to resist that? And there were a couple of strategies that we came up with, and I just give these as illustrative examples. Like there's probably countless more ideas that we didn't come up with, because our imaginations as lawyers are limited. Like we're taught to limit our imagination. So, but these are the strategies we came up with. On the one hand, we insisted that once we arrived at a certain point in the negotiations that we could not give final approval, that just based on the plaintiffs alone, that because of the way this litigation had grown out of community organizing efforts, once we reached a certain stage in negotiations, like sort of close to the finish line, we had to be able to take the proposals, like the parameters of the settlement, and make them public, and have discussions and we negotiated for that, and the city agreed to that. So both parties, like in a technical sense, agreed to waive the confidentiality under the federal rules of evidence that like cover settlement talks. So that was a condition. We fought for that so that we weren't going to give like our clients who were also themselves organizers. And those were the folks who decided to step up as plaintiffs because that was a significant risk to themselves to sue the police, to sue the surveillance apparatus. They were the ones who drew a line and said, we're not going to sign off on this as plaintiffs unless there are broader conversations that happen, so we can make sure that there's broader buy-in within the ecosystem before we say yes as plaintiffs to these proposals. So that was negotiated, and we got that. The other thing that we did was, there's a relatively obscure proceeding in class actions called a fairness hearing, and we insisted on that. So what that means is, once the plaintiffs have said okay to a set of proposed like settlement like specifics, before the court orders that settlement, the court has to hear from anybody who is a member of the class. And the class was all New Yorkers, all residents of New York City. So there were 2 3-hour sessions in federal court where anybody could walk in off the street and basically say what they thought about the settlement proposals, and the details of that had to be made public by the city and by the plaintiffs. So we insisted on that as well, and that created sort of that rare space in federal court for organizers who were not plaintiffs and just community members who were not involved in the organizing to come in and tell the judge whether they thought this settlement should be approved or not. And I'm not saying that's perfect or that we couldn't have done more, but those were some concrete examples of what we were able to do to get around this challenge, of dividing, the plaintiffs from the broader ecosystem of which they're a part.
I think those kind of concrete examples are really helpful in thinking, how do we push back and in the constraints that we sometimes have. Ramzi, you mentioned earlier that you don't have to make the decision of what to choose because it's a community that brings, in terms of like new litigation, it's a community that brings it to you all. I'm curious kind of from each of you, how do you define exactly who you're accountable to? Because we're using the word community kind of left and right, but which community is going to drive the litigation, and kind of what strategies do you guys use when conflicts or differing positions arise between community members and groups involved in litigation?
I can share very clearly for us. We're grounded in the fact that for our purposes, community is defined as Black folks living in Miami-Dade County. We're fortunate to be a hyperlocal organization, but not only that, we are very clear about centering how things impact folks that are at the intersection. So undocumented folks, queer folks, folks that are otherly abled. And we're operating in a state, particularly with this litigation, one of our guiding posts for why we saw HB1 as being so dangerous is because we knew that this law would disproportionately criminalize Black people in our state. And we knew that there is a very concrete impact to folks being criminalized and that they would lose their voting rights. So we still are in a state where you can, being convicted of a certain level of crime can cause you to lose your voting rights. And there is still a quite nebulous way to get those back. So it is a very direct threat to power for us to be able to have political power in our state. And so when we look at what success looks like, or when we look at potentially settling a case or winning or whatever that may be, we're thinking about, does it actually improve the material conditions of folks who, should they be arrested at a protest, are facing deportation, or folks are faced with losing their voting rights, or folks are faced with losing access to housing, because we do have major challenges with folks with prior convictions having access to housing, and we're also in the midst of a housing crisis, right? So we're really intentional about whether or not this has a material impact on our people that can be measured and weighed in that way.
Yeah, go ahead, Alana.
No, go ahead, okay.
I won't take it too long, but yeah, I think for us, just to, again, make sure that it is clear, right? For us, our community is undocumented immigrants living most of the times in the Chicagoland area, even though we do have members that are across and even outside the suburbs. I think when we talk about like the difference, or when kind of conflict or differences in strategy arise, that's when we have to remind each other and to practice, right, the amount of trust that we say that we want to create with one another when we start those collaborations or those conversations. And to practice trust, that takes a lot of vulnerability. That takes a lot of like listening and being comfortable, right, with being uncomfortable in a way as well. And so that in itself has been like a key component for us, right? Like, do we trust these attorneys and kind of their opinion in regards to like what is next in the litigation steps? And as OCAD, that is gonna be something that we constantly do, not only after that specific meeting, right? But even after we are done potentially with the litigation, to continue to debrief and continue to understand like which attorneys are good for certain like cases and campaigns, which attorneys are the ones that we want to continue building more of a relationship in regards to litigation, because they tend to be good allies, be good in those spaces with our community members, and really tend to like listen to their demands. Yeah, so that aspect of debriefing, that process is going to be a very key component for us, and how you build trust, right? That really relies on like relationship building. So we tend to like also do one-on-ones with many of the attorneys that we work with. Some of the attorneys that we have worked over the years, right? Like have gone now for like 5-7 year relationship with the organization. So that's going to be another key component, that we go beyond just an organization collaborating with another entity, right? Or legal aid organization, but instead like humanize each other so that we can see that vulnerability and create that relationship with one another as well.
I was gonna say for us, I mean, I think it's really important. We spent a lot of time, and my mentor really drilled this into us, thinking about like who our client is, and not like, and being really clear about in working with organizing groups, like that there is a group of organized people with a demand, with leadership structure, formal or informal, of some sort. And that is really vital to like maintaining the accountability that we need to do this work in the right way. And I think as lawyers in particular, it's like, I think it can be dangerous to think of community in amorphous terms, and it's really easy to take too much space in that when you don't have that accountability structure, that relationship structure. So that's a big piece of it. And I think, Gabrielle, you asked about like kind of how do you deal with like challenges that come up intra-community. And I think first, I think the reality is like any group of humans that are getting together, particularly in moments of crisis, in moments of extreme pressure and oppression, there are going to be disagreements. There are going to be disagreements between you and you guys, are going to be disagreements between groups. You're going to be disagreements with the other lawyers and the groups that you're working with. And so understanding like that you're going to have to confront that, and like really creating the space to build human relationships within that, and build the containers to work through those as they come up, I think is the most important thing. And if we're caught off guard, if the surprise if those things happen, I don't think we've like prepared ourselves right for just the reality of doing this work in the trenches, or not even in the trenches. This work happens, when you're in relationship with, at your law firm on the 79th floor of the building, like, that's the reality of it. I think the difference in movement lawyering versus traditional lawyering, I think, is really being intentional about creating the containers to hold that process and being dedicated to the relationships and the trust that need to exist beyond this tactic, beyond this piece of litigation.
That's so helpful. I guess this question is in light of the fact that we have a number of law students in the room. And what I've loved about this panel is that we've had the chance to hear from the perspective of attorneys and organizers, and that's just been kind of intermingled. And this one, I'm going to kind of separate out a little bit because I think it's a slightly different question for each, but hopefully I'm excited to hear from each of you. But so for those who are attorneys, what have you learned from the organizers and communities that you've worked with in these types of litigation that you wish you had learned in law school? And then for the organizers, what do you wish lawyers knew from the start of their careers, really before you had to begin working with them? So I'm happy to have either Antonia or Christina start, or Alana or Ramzi. I can also just call on people too. That's fine with me. I'm going to go with Alana since she unmuted.
I think, especially organizers that were like newer to working with us or newer to working with lawyers in general, I would love, if folks, I think one of the learning curves we have is like, we don't just have litigation as this, like, you don't just have to send us off to court and never talk to us again, right? Like there are all these creative ways we can use these tools that can actually really benefit organizers, like day-to-day goals. And I think you got to do the work together to like experience that and see that, like that, what more is possible than just, oh, could you go sue those people for me? And I think it's so, like nourishing when we actually get in that rhythm with folks, and the creativity of the community leaders we work with like gets to be brought into that strategizing space, I think is when the real work happens. So I think that's.
I think in regards to what I wish or what I have seen that makes a good community lawyer within the collaborations that I have personally done, right? And I mentioned Beyond Legal Aid in the beginning of how instrumental they were in the conversations of like how we created our model of organizing as OCAD. But I also was at one point a staff member of Beyond. So I got to interact with attorneys, right? Not only as an organizer outside the office, but also as a colleague, as a co-staffer with them. And even like started at one point, like supervising how they were building those relationships with the community partners that Beyond had. So I understand and kind of have created like an understanding of a curriculum that people need to like go through in order to really be able to be like successful community lawyers. What I will mention in there, right, is that like the importance of conversations around like how to be an ally need to be had. Attorneys need to understand, right, that these conversations, these litigation projects are not it's not their time to shine, but it's really a time for the narrative of those directly impacted to be amplified, to create a platform for them, because they have never had that. This aspect of humbleness, right? That yes, attorneys come with a lot of really good knowledge and understanding of the law and understandings of like things that I don't have the training of or the understanding of, or that I even get limited in regards to practicing, right? Like unauthorized practice of law, and making sure that even though I understand my rights as a tenant, even though I understand the deportation process and timeline for the immigration system, that I still cannot give quote unquote, right, like advice to individuals or like an understanding of those processes without an attorney being present with me or without them being the ones speaking up about those processes and me having to stay silent because of those laws that prevent me from really becoming a community paralegal in the sense that we are discussing in this symposium. We need attorneys to understand that organizing gets the goods, that we are not going to be winning stuff. We're not going to be creating systemic change in the courtrooms. Organizing is a needed component for successful litigation, and for successful litigation that keeps pushing those boundaries and keeps thinking outside the box. And finally, our community has infinite creativity, and we understand and know what it's going to take to create alternative systems to the oppressive like systems that we experience every day. We are what we need is one of the values for OCAD, right? We create things that we understand we need, and we have the resources and the power to do so.
I can jump in, just to answer the question. I guess my short answer to the question is everything. Everything that I know about the work that I do, I've learned through my work with the clients, the communities, and the movements that I've had the privilege to work with. And compared to that, what I learned in law school is next to nothing. I know that to the law students here, to some law students, this will be deeply encouraging and motivating. And to other law students, this will be deeply demoralizing to hear. But that is my particular experience. I also recognize that it's rooted in, my own reality. Like I went to law school at a particular time and place that hopefully is different from, the time and place that the law students here are going to law school. I took away some valuable things from law school, how to read cases, how to blue book, I guess. But again, that is a drop compared to the ocean of learning about the work that I do, that I've had the privilege of, engaging in that process of learning and growing in partnership with the clients, communities, and movements that I've worked with.
That really resonates. I answered the wrong question before, but I just wanted to add for law students, you have space to craft your own experience within that, right? Like it's not just the black letter law classes that law school can exist for you. So like I was incredibly lucky to have mentors that worked with organizers like City Life Vida Urbana, go do clinics, go take summer internships with folks who are working in community, and go out there and gather that experience, even if it's not presented to you as a curriculum plan by your school,
And then I would add, find what you are passionate about and find the people who are working on that issue and offer your time, talent, and treasure outside of your legal capacity. Like one of the common themes that I think we've all touched on is trust, and that relationship building is I believe the secret sauce to really great lawyer organizer collaboration. And it really comes from a place of like passion and purpose, right? And sometimes when you're in the trenches of your legal study, you kind of lose that. So I would say to definitely find your people. And I think that makes a difference. And I think that over time you can bring the legal knowledge and your privilege as an attorney to the fights that you care about. And then lastly, really think about like, what is your theory of change and what are your core beliefs around existing systems and structures? You're going to have your formal legal education that is going to teach you a set of things, but you as an individual should actually wrestle with some of these existential questions and see how you can use your legal knowledge as a tool to fight for liberation and transformational change in the ways that are aligned with your own personal values.
Thank you so much for that. I think so many of the things you guys mentioned were things that like helped me get through law school for sure. I think I just want to, in the interest of time, I'd love to, if there's a question that I have not asked you or something that you didn't get to share that you'd like to just leave this community with that we've hopefully started to develop, I'd love to make space for that. I'll start with you, Ramzi. Is there anything you'd like to share?
Yeah, I mean, I think there's no, I can't remember who wrote this, but it was in connection to psychotherapy and how, you know, there's really no substitute to genuine empathy, and a patient will immediately see if their therapist is not genuine and, you know, sincere. And I think that carries over to the work that we do. There's really no substitute for, you know, being sincerely committed. I mean, that's much more important than the legal skills, which you can learn and pick up along the way. But like a sincere commitment and the willingness to spend the time. I mean, and this I think echoes, you know, what Christina said earlier. You really, to build trust as a lawyer who wants to work in movement spaces for the long term, you have to spend the time. You have to be in those spaces. You have to be engaged in those conversations. You have to be a repeat player. You can't just like parachute in and then disappear for 2 or 3 years, right? And only then, I think, will there be enough trust for folks to talk to you about transformational strategies and how to implement them, and what role a lawyer might play in that process, and what role litigation might have in there. But there's no shortcut around that. So, you know, the reason I share that, I think, knowing that there are a lot of law students here, is because, you know, that's something that you can already do, right? That's something that you already have, that you already possess, that you can already commit to. The rest will come with time and practice.
I think what I will add is that the importance of, when doing community-driven litigation, is also important to continue to discuss within the process what the implementation of that litigation or the settlement is going to look like. We have seen this firsthand as OCAD, right? That implementation of new policies, of new laws, of new kind of settlements that we're able to negotiate with entities like ICE, is really important that that process is also community driven, that there's a process for how the community is going to be able to debrief of that implementation, support with that process, and how, of course, like we're going to make sure that that settlement talks about the specific clauses or specific things that are going to be provided to the community in order to do so. And I think the last thing that I will mention is that community-driven litigation, as we all like discussed today, like takes a lot of time and it takes a lot of effort, and it's going to be more difficult than traditional like litigation as we understand it, right? But is potential possible empowerment that it could have in individuals, in organizations like OCAD, will go and create an impact for those communities to feel supported for generations. So it is worth the investment of that time, right? Because we are creating that ripple effect that will create like social movements that will and have to believe that transformation is possible.
I'll just add really quickly. Oh no, go ahead, Alana. So I'll just add that for me, one of the invaluable things that we've gotten out of this experience with the litigation that we're currently in is actually we have greater collaboration with our legal partners, and now we're interweaving this like analysis and consideration into all of the work that we do. So like this legislative session is particularly horrendous. You may have seen we are known for at least 3 or 4 bad bills right now that are being fast tracked. And I think one of the things that gives us hope in this moment is knowing that we actually have this tool, or we have a way to shield our community, making reference to that before, and looking at how, just like how the state is adapting to our strategies, we are also adapting to their strategies. And I think that it's really this community-driven litigation is one of the most effective tools to be able to respond.
Yeah, I would just say like my lesson, I think particularly for law students who are going through this right now, like as someone, I'm not a natural litigator. I'm not someone who's like driven to courtroom litigation as like my preferred mode of lawyering. And I think my lesson from doing this work on the ground over years has been over and over again, like communities and organizers need and are asking for you to be highly skilled in this tactic, right? Like it's not just, I spent a lot of time rejecting my development on these pieces because I wanted to explore these other things which were important and valuable, but I think we really need to be the opposition, the folks who are running these bills have stables of lawyers, right? And we need to be that they need to have the same access on the community side to those kind of skills to tap when they want to. And so it's really, I think, for those of us who have the privilege and the access to get an education in law school, to really absorb as much of those skills as possible so we can put them to use when we're asked.
Thank you all so much. I know and I think I speak for everyone who was able to assist to this panel, have learned so much from everything you all shared. So thank you to each of you, and thank you, Sukti and Tyler, for allowing me to moderate. I think the only thing I will leave with is the next panel is starting at 10:45, and that panel will be focusing on challenges to advancing legal empowerment in the US. So I'm looking forward to that. Thank you all again. Have a good day.